Hello, my name is Mary Dahl and I am a partner at Seacrest Wardle. I'm here today to discuss third-party contractor liability. What are third-party contractors? Some of the more common ones I have listed are landscapers, snow removal companies, roofing contractors, etc. Lawsuits against these companies, especially here in Michigan, generate a lot of opinions from the Court of Appeals with regard to whether they adhered to the terms of the contract, which generally have requirements as to the laying of salt and plowing, or what should have been done as far as safety concerns. Before you get to an actual judgment, though, the plaintiff must first show negligence, as you all know. So you must first establish a duty, and that is where we go when reviewing a third-party contract. What were the duties of the parties that entered into that contract? The duty in a premises liability case arises out of either a statutory duty, which you could find in a tenant-landlord situation, a contractual duty, which is the basis generally for third-party contractor liability cases, and common law duty. A third-party contractor case will usually be a contractual one arising out of the contract between, say, the premises owner and the snow removal company. So what is the duty of a third-party contractor? We have some case law which we generally turn to when determining the duty of the contractor. In 2002, the Court of Appeals issued the opinion in Derbabian versus Mariners Point. Defendant was a snow removal contractor. The court held that he had no common law duty to inspect or salt the parking lot. The Court of Appeals held that the defendant did not breach the duty of care when he failed to inspect the lot on the date in question. The plaintiff did not have an independent tort action against the defendant third-party contractor, the snow removal company. So there is a distinguishing element which was mentioned in this particular opinion pertaining to misfeasance and nonfeasance, which was discussed, as I said, in this court case. Nonfeasance is a failure to perform a contractual duty, whereas misfeasance is an active negligent act in failing to perform a contractual duty by actively causing a danger. This distinction becomes an integral part of later cases. In 2004, the court came out with the Fultz versus Union Commerce Association case, which was a notable decision by the Supreme Court at that time. The plaintiff had slipped and fallen on an icy parking lot, which the snow removal company had been contracted to keep clear of ice and snow and allegedly failed to salt. The Supreme Court found that the misfeasance-nonfeasance analysis discussed in Derbabian was too slippery. So the court looked at misfeasance as a separate action distinct from that of any contractual duty. The Supremes found that there was nonfeasance as opposed to misfeasance, but the court did not provide a detailed analysis of its separate and distinct approach. The court, however, stated that since the plaintiff's tort claim was based on defendant's failure to perform its contractual duty of plowing and or salting the parking lot, the claim failed under this separate and distinct analysis. The plaintiff's cause of action against a third-party contractor was then dismissed. Going forward from the Fultz case and its progeny, the court has taken some leeway from its Fultz analysis. And I mention Banasek and Mizurski as cases which departed from the Fultz progeny. In Banasek, the third-party contractor was Otis Elevator Company. They were contracted to install elevators and moving walkways at Metro Airport. They were also required to cover a wellway, which held the mechanical equipment for the walkways and was at the end of that moving walkway. Plaintiff was injured when she stepped on a piece of plywood that was acting as a temporary cover for the hole. According to the Supreme Court, the wellway was the subject of the contract between Otis and the airport. So Otis owed no duty to the plaintiff that was separate and distinct from the duty under the contract. So even though Otis clearly increased the danger to the plaintiff or otherwise created a misfeasance, the court held that there was no distinction between the misfeasance and the nonfeasance, so there was no breach of a duty separate and distinct from the contract, which is in sharp contrast to the Fultz case. Similarly, in Mazursky, which was later rejected in Lewicki, the defendant created a misfeasance by piling the plowed snow from a parking lot onto a landscaped curbed island in the parking lot. The argument was then that this action created a new and dangerous hazard because of the melting and refreezing of the piled up snow. Again, the Supreme Court rejected the argument that the plaintiff was owed a duty separate and distinct from the contract, even though similar to Banaszak, there was a misfeasance or the act of creating a more hazardous situation as opposed to a nonfeasance. Next, we come to the Lewicki versus Ann Arbor Ceiling case, issued in 2011. This overruled both Banaszak and Mazursky, and also post-Fultz decisions, which tried to do away with a separate and distinct duty regarding misfeasance. In Lewicki, the accident occurred at a construction site where the plaintiff was working for an electrical subcontractor. The defendant's employee left a bunch of cement boards stacked against a hallway, which then fell on the plaintiff and injured his leg. The Supreme Court rejected the Court of Appeals and found that Fultz did not distinguish the simple idea that is embedded within the American common law of tort. If one having assumed to act does so negligently, then liability exists as to that third party for failure of the defendant to exercise care and skill in the performance of the act itself. So Fultz did not extinguish that common law duty, such as the duty to use ordinary care to prevent harm to foreseeable persons or property. Rather, the court found that the initial inquiry, aside from the contract terms itself, should be whether there is an independent legal duty to the plaintiff. Contracting parties does not extinguish or limit separately existing common law or statutory tort duties owed to a non-contracting third party in the performance of its contract. So essentially, Fultz was brought back to its original and primary holding by the Supreme Court in Lewicki, analyzing the difference between a nonfeasance and a misfeasance, and whether a person who is not a party to the contract can then sue for a breach of that duty arising out of a misfeasance. So then we got to Hill versus Sears, Roebuck and Company in 2012. This was heard before the Supreme Court in Michigan. In this case, the issue focused on whether an appliance repairman from Sears had a separate and distinct duty from the contract to install appliances. In Hill, the plaintiff had purchased a washer and dryer from Sears. The installer came out from Sears. There was apparently an uncapped gas line in the area where the washer dryer was to be placed. The court said that due to the limited relationship between the installers and the homeowners, the installers, did not have a duty to take any action with respect to the exposed uncapped gas line, nor did they have any duty to warn the homeowner of the uncapped gas line. The installer did not create a new hazard by placing the dryer in front of the already existing uncapped gas line. Bailey versus Schaff is an odd case. This is a 2013 case, and I included it because the court remanded it back to the Court of Appeals to determine what a security company's duty was under the Lewicki's decision, and with clarification from Fultz as to the nonfeasance versus misfeasance argument, and a separate and distinct duty to the plaintiff. The Supreme Court examined whether the third-party contractor, a security company called High Tech, which was hired to patrol the premises, was under a duty to the plaintiff to provide security services for that premises owner. Apparently, the plaintiff ended up being shot and paralyzed at an outdoor event in the premises common area. The Supreme Court focused on the landlord management duties to the plaintiff to notify police if given notice of a dangerous or criminal activity on the premises. The Court of Appeals originally found that the contract between High Tech and the landlord would impute the landlord with notice of the criminal situation. The landlord had a duty to inform the police. However, when the case got to the Supreme Court, the justices felt that the matter should go back to the Court of Appeals for a consideration of the nonfeasance versus misfeasance argument under Fultz and Lewicki, and to decide whether there was a duty on the part of High Tech. The Court of Appeals then decided that High Tech had no duty to protect the guest and that the claims against High Tech were dismissed. However, the claims against the landlord were not. The court found that the landlord had a duty to protect the guests from the criminal acts of third parties when it had notice of a specific situation that would cause a reasonable person to recognize a risk of harm to an invitee. So, if a third-party contractor, such as a landscaper, must do their job reasonably and with care, is there potential for liability to arise if they do not do their job reasonably and with care? Yes, if a contractor acts unreasonably, regardless of the contract language, liability can be imposed. Now, we have all heard about the court's recent ruling in Candy El Sayed and in the Pinsky case, and the impact on the open and obvious doctrine. How does that affect, if at all, third-party contractors' liability? In Ghaffari v. Turner Construction, the Supreme Court held that open and obvious defenses do not apply as it is specifically applicable to a premises possessor. In Ghaffari, plaintiff was a subcontractor working for the defendant, so not like the normal scenarios where an invitee would slip and fall on ice or trip on sidewalk. The plaintiff in Ghaffari tripped on some pipes in the ground. The Court of Appeals applied the open and obvious defense and dismissed all of the plaintiff's claims. The defense bar cheered. The Court of Appeals said there was nothing to suggest in the open and obvious doctrine that it would be restricted in its applications. It was then taken up to the Supreme Court, who reversed, and the defense bar booed. The court said that the doctrine was specifically applicable only to the premises possessor. The rulings in Kendall and Pinsky do not overturn or distinguish the liability of a third-party contractor as it pertains to open and obvious doctrines as of yet. In stretching the issue of possession of a premises, the court in Finazzo v. Fire Equipment found that the open and obvious defense would, however, apply to non-premises owners who are ceded or loaned possession and control of the property. The court found that the ones in possession and control of the land are most able to prevent harm to others. Subcontractors and contractors would have the same defenses as a landowner if they were found to be in possession and control of the property at the time of the occurrence. Jumping back to Candile, it should be noted that the retroactivity of the ruling could apply to those matters pending at the court. However, again, its application for third-party contractors seems unlikely under Ghaffari, but never say never with the present court. Bottom line is that unless duty to the plaintiff is found in some fashion, liability as to third-party contractors remains elusive, at least for now. Look to the contract and the circumstances surrounding the loss to determine if there is exposure to a potential liability claim. Your clients will appreciate that. This requires an analysis of all the factors, not just the contract. This concludes my presentation on third-party contractors. If you have any questions, I am in Seacrest Wardle's Troy office. My direct line is 248-539-2824, and my email is mdahl@seacrestwardle.com. Thank you.